Welcome everyone in the webcast audience. I'm Terry Maggedy, chair of our Elder Law Committee of the Trust and Estates section. And the first thing I do before anything is show our appreciation. And that appreciation goes to our sponsors. So because they are the ones that really make it happen, that allow us to keep these programs going. And we have sponsors that have been with us a long time, and quite a few of them, and they're great players in their fields. So we'll start with our first sponsor, the Sanborn team. Nancy Sanborn and the Sanborn team, they're real estate brokers who work in conservatorships, trusts, probates, special issues dealing with older people. A great outfit. They've been our sponsor for a very long time. So thank you, Nancy and the Sanborn team. And our next sponsor is here in person, which is a pleasure, Zoom person, a friend, and also just a fabulous real estate broker, Orit Gadish, and she'll tell you more about her company.
Thanks so much, Terry. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate, specializing in representing trustees, executors, and administrators. I'm excited to announce that a couple weeks ago, I launched the Probate and Trust Academy, where we offer courses on real estate, business development, and technology to attorneys and professional fiduciaries. These are not formal courses. They're topics of conversation that last 30 to 60 minutes and are free of charge. Check out the wide selection of topics online at www.probateandtrustacademy.com. The link to the Probate and Trust Academy website is in the chat box to the right. I also have two new interesting posts on my probate real estate blog. The first one discusses why I launched the Probate and Trust Academy. And the second one is titled, Does a Quick Sale Require Auction? The link to my blog is in the chat box. It's oritgadishprobateblog.com. Enjoy your program, and back to you, Terry.
Thank you, Orit. And our next sponsor is an escrow company, Glen Oaks Escrow, and its principal, Marcine Klein, an escrow company that, again, specializes in our space that we're in. Escrows for older people, escrows in probates, escrows in conservatorships, escrows for trusts. They do a great job. Thank you, Marcine and Glen Oaks Escrow. And our next sponsor is a title company, a California title company, and they deal in the same areas that I mentioned before. Their ad there, working with the trust and probate community. Really like all the other sponsors, they're folks and organizations who specialize and work in our field. So thank you, California Title Company. And our next sponsor is Manufacturers Bank. Again, an organization, a bank that knows how to deal with conservatorships, trust accounts, blocked accounts, probate accounts, all the various specialized things that come up in our business. So thank you, Manufacturers Bank. And we have a new, this is not a sponsor, but I think it just reflects good commerce on behalf of the Beverly Hills Bar Association. And that is, this program will be available in a couple of days at the Beverly Hills Bar Association on demand. I guess that's someplace you can just push and pop in and get the program. And that is all thanks to Beverly Hills Bar Association's new member benefit presented by Lawyers Mutual Insurance Company. So thank you, Lawyers Mutual Insurance Company. And next, I want to describe the program that is coming up. And that's going to be September 30. You want to mark this down as soon as I describe it. And it's going to be part of a series we're doing where we're going to be talking about elder law internationally in countries all over the world. And this topic, we will be starting with Israel. And the title is going to be, title is Older Clients and Their Families Who Have Ties to Israel, how counsel can help them navigate the challenges. And our speaker, attorney Osher Felicia Halali, is going to talk about this subject. And I'm just going to read, usually I don't do this, but I'm going to read 2 sentences to pique your interest. So for this from the program description, so many clients wonder whether their U.S. wills, trusts, and powers of attorney will suffice for assets they own in other countries. Often they will not suffice. Well, that should pique your interest. So, and if you want to hear more, come to the next program, and there'll be more international programs after that as well. And now for our speaker today, it's a pleasure to introduce Brittani Trujillo. And there's such, I guess you could say there are negative parts of the internet, of course. But one positive part of the internet is when I'm talking to someone, in the industry, assisted living industry, developmental disabled industry, and world, and they're sharing with me how, this thing called the final rule is coming out, and we're all like working to trying to adapt to it. And so I read a little bit about it, but they referred to a consulting firm that seems to be the consulting outfit that's not only helping advise, our state and agencies in our state, but agency and states all over the country. And so I just Google it, and up pops a great article by Brittani. And so I just emailed her because she seemed like, the right person to speak on the topic, and she is. So with that, I'll turn it over to Brittani, who's been, there's more in her bio you'll see in the screen, but senior consultant in this area, 18 plus years in the home and community-based services programs, very experienced and knowledgeable. So with that, I'll turn it over to you, Brittani.
Thanks, Terry. Good afternoon, everyone. Let me get the presentation up and we'll kick things off here. Okay. Again, I'm here to talk to you all about the Home and Community-Based Services, or HCBS, settings final rule. Our agenda today, I will give a quick overview of Pubic Consulting Group and a quick introduction of myself as well. Then we'll talk about the HCBS final rule, some background and highlights, person-centered service planning, what comes next, and then any questions questions that you all may have, we'll try to answer those as well. So a little bit about PCG and myself. Pubic Consulting Group has been around since 1986. We are headquartered in Boston, Massachusetts. We do employ more than 3,000 people in around 40 offices. That has changed some over the last couple of years. Obviously, due to COVID, we have fewer offices than we did 2.5 years ago. But we are a management consulting agency that primarily works with public sector agencies. So we work mostly with state government agencies across the human services, health, and education fields. But we also do work with counties and cities. Through that work, we do end up working with a lot of stakeholders because of those projects. So it could be service providers or individuals who are receiving the various services from whatever those agencies are. We also do technology consulting in various states. A little about me. Terry did share some of my information, but again, I am a senior consultant with Pubic Consulting Group. I work in our Aging and Disability Center of Excellence, and I'm housed in our Human Services practice area. So I do a lot of work on human services programs, but that does cross into health because the programs we work with, many of them are funded through Medicaid programs or dollars. I live in Denver, Colorado, born and raised here, but have been to California. And I do have over 18 years of experience with the HCBS programs, a lot involved with stakeholder engagement, aging and disability services, helping redesign systems, developing new policies or revising policies. Prior to my work with PCG, I've been here about 2.5 years. I did work at the state Medicaid agency in Colorado, managing our case management system and agencies across the state with about 47 agencies, providing services to more than 60,000 people. I began my career as a case manager in Colorado and again, eventually worked in state government before coming to PCG. Let's dive in a little to the HCBS settings final rule, some background and highlights of that rule specifically. Here we have, again, how is the HCBS settings final rule often referred to? You'll hear it in a lot of different ways depending on who you talk to, but the final rule is the most common, I think, that you'll hear. The official title of the published rule is there on your screen. I'm not going to read that to you, but I believe you all will have access to this recording, and I did provide a copy of the presentation as well. The final rule was originally published in 2014 and went into effect March 17th of 2014. So we are coming up on almost 8.5 years since this rule became effective. States must be in compliance as of March 17th, 2023, but that is, I believe, the third deadline that has been put into place. The original deadline was March 17th of 2019. And then in May of 2017, the federal government said, well, we will extend that to March of 2022. And then in July of 2020, due to the public health emergency, they extended that to March 17th of 2023. That date has not been extended any longer, and I don't foresee that happening, but I also do not work in the federal government, so I never say never, but they are moving forward with that date as of now. A little bit more about the final rule. What are we really trying to do, or what was the federal government trying to do when they drafted this rule and then made it effective? Really, we're trying to ensure that individuals who are receiving services through these HCBS programs have the same access to the benefits of living in the community as anyone who is not receiving those services. It's really starting to look at and trying to shift the system to working with people as people and not as their disability or just because they are of a certain age, but really let's work with people and as individuals. And you'll see that throughout as we talk a little bit more about the final rule and its requirements. The final rule also really expanded on the opportunities for meaningful engagement in community integration. It really supports those goals of the ADA as well as the Supreme Court decision in Olmstead. And we're really trying to enhance the quality of HCBS that people receive and make sure that they also have protections in place. Some additional highlights. So the final rule is really defining and describing and aligning those HCBS setting requirements across various Medicaid authorities. So HCBS programs are governed by various federal authorities. And so this really started to create consistency across those programs, regardless of which waiver or authority was funding it. The federal government really wanted to streamline those programs, avoid contradictions, and make them, again, as aligned as possible. The final rule also defines person-centered planning requirements for individuals who are receiving HCBS waiver services. So it really defines that role of person-centered service planning, including the process by which that should occur or how it should happen and what should be in that person-centered plan. But we really want to start looking at what are people's preferences for their services, for their lives, what are their needs, and not just those related to what can be provided through a waiver. What are the person's goals? And really making sure that we're looking at a time and a place of that meeting that's really convenient and chosen by the person. And we'll talk more about that a little later. Another highlight is that the final rule provides CMS with additional compliance options for these programs. So though they now have CMS, the Centers for Medicare and Medicaid Services, I apologize, the federal government, now has authority to really develop additional rules and practices to ensure that states and their programs and providers are complying with these requirements. Let's dive in now to more about the actual HCBS final rule, what those characteristics are looking like for settings, what it means in terms of provider compliance. So this first list, these first 5 are applicable to all HCBS settings. So that means those residential settings such as assisted living facilities or group homes, for example, as well as non-residential settings. So those day programs, employment services, things that are more community-based versus home-based. So again, these first 5 are applicable to all of those. And the first characteristic is that it's really provides and supports integration and access to the broader community. So what are those settings doing and those providers to really help people be involved and engaged in their community and whatever community means for that person? I think if we were to ask all of us, what is a community or what is your community, it might be different and defined differently based off of who we are, what's important to us, what we like to do. So the final rule is really saying providers in these settings, how are you supporting people to be integrated and accessing their community? And not just disability specific communities either. And when we talk about integration, it's really not just I go to the, quote unquote community. I don't think any of us ever talk like that, but it's how am I developing connections and relationships within whatever that community is for me, above and beyond maybe just paying for something at a 7-Eleven gas station. It really is meaningful community integration. The next characteristic is that setting and that service are selected by the individual among all options, and that it's not just non-disability specific, or that it's not just disability specific settings, I apologize. But what are all the options available to me to support whatever my needs are? Whether those are my needs for, my activities of daily living, so something that helps me, take a shower every day, or if it's my need for social interaction, that I'm given a broad range of options and that I'm selecting which one works for me. Another characteristic is that setting or those providers are really ensuring that the individual's rights of privacy, dignity, and respect are in place, and that they are free from coercion and restraint. So we're looking at privacy when I'm, using the restroom, or privacy in my bedroom, for example, privacy when I'm looking at my mail or having conversations with friends or family or whoever, that I'm treated with dignity and respect, again, as a person and not as a person with a disability, or not as my disability, that I'm not being coerced into making decisions or choices, or to participate in things that I'm not interested in, and that I'm not being restrained physically, mechanically, chemically, that's just not something that happens to control me in some way. The settings or characteristics are also really looking at optimizing autonomy and independence and making my choices. So what do I want to do with my time? How do I want to spend my day? If I don't want to go to a movie, if I live in a group home, for example, and I don't want to go to a movie with everybody, that I have the ability to say no, and that I can schedule my day the way that I want to, and that I had to make choices if I want to vote, for example, or attend church services, whatever that might be, that the setting is supporting me in doing those things. And that we're also, as the settings and providers, helping to facilitate choice for the person regarding their services and who provides them. So not just which services am I receiving, or is the person receiving, but if I have preferences on who provides those services, if I prefer a male or female caregiver, that I'm able to express my preference, and that the setting, to the extent possible, is able to meet that. We understand and know that that's not possible at all times, but that that choice is facilitated. And if it can't be met, there's a discussion about that. And it's not just a too bad, so sad, that doesn't get to happen for you. This next set of requirements is more and only related to those settings that are provider owned or controlled, which are really those residential settings. So again, those assisted living settings, group homes, it's those residential places where somebody, that is their home, that is where they are living. So some additional requirements for those settings is that the individual now has a lease or some other legally enforceable agreement that has protections similar to that of somebody with a lease. So if I were to rent an apartment, for example, I have to sign a lease that talks about what my rights are, what my protections are from being evicted, what my responsibilities are in terms of living in that setting. The HCBS final rule says that people residing in those settings should have something similar, and that it really does lay out their protections from just being evicted, their ability to file a grievance about the setting or the process by which they may be asked to relocate. But it's really preventing settings and providers from maybe working with somebody who at sometimes maybe exhibits certain behaviors that can be disruptive to others. That setting cannot just say, you have to be out today. There are some protections in place now, and that gets signed at least upon move-in, and ideally that's redone annually. Another characteristic here is that the setting is really helping ensure individual that they have privacy in their unit, which means that in my bedroom that I have a lockable door that only I have a key to, or appropriate staff, and that they can't just barge into my room. That I also have a choice of roommates in settings where I have to share a room. I don't just get put with somebody in a room and that's it, that there's a process for changing roommates, and that people know about that process, and that I can also furnish and decorate my room the way that I want to. It's not saying that providers cannot provide the furniture. I know a lot of providers do that. But if I want to bring my own furniture, if I have additional things I want to put in my room and I want to decorate it in a certain way, that I can do that. It is my choice, and it's not just a provider thinking they know what I might like. Another characteristic is that the individual really controls, again, their own schedule. We've talked about that, as well as access to food at any times, or at any time throughout the day. I know in a lot of residential settings, it's been a history or a practice for just the way that settings have evolved over time, that there are set meal times. We do breakfast at 8, lunch at noon, and dinner at 5. That is very institutional-like in feel. Hospitals often operate that way. Nursing facilities often operate that way. So this is really saying I can have food whenever I want. It's not saying that settings can't say this is in general when we like to have those meal times occur, but if I'm somebody who wakes up at 6 a.m. and want to eat breakfast at 6:30, that there are options for food for me at that time. This doesn't mean that those settings have to have a chef or somebody cooking 24/7 and make, scrambled eggs between 5 a.m. and noon, for example, but that there are other options for me at breakfast time if I want to eat something different. And that I don't just have to ask staff to get that for me, that I have access. I can keep a small refrigerator in my room maybe, or a little pantry where I can have my own snacks, or a microwave, or things like that. How do I have that access? Another piece is that individuals in those settings can have visitors at any time, which also means overnight visitors. A lot of settings that we've interacted with across the country, have those set visiting hours between 8 a.m. and 8 p.m. Again, very institutional-like. Hospitals, nursing homes, they have very similar visiting hours. This now says I get them whenever I want. And if I want to have an overnight visitor, I can. It doesn't mean that settings can't say, we want to have some structure around this. If you want to spend the night, we'd like to have a heads up. And if somebody shares a room with somebody, that there's a discussion with the roommate, and that, that's figured out in some way. So it's not saying that people just be walking in and out at all hours and all day, but that I can have them regardless of my age or my disability. The last piece is that the setting is physically accessible. So if I live in an assisted living or group home, for example, and I use a wheelchair to get around my environment, that there are ramps for me to get in and out of that setting, that I don't have to solely rely on staff to do that, that my wheelchair fits through the doorways, it fits into the bathroom, that there's a roll-in, maybe a roll-in shower, the equipment exists, that I can access all parts of that home physically based off whatever my physical needs are or aren't. A little bit more about the final rule requirements in terms of the provider side of things and what those settings are supposed to be or not be. Well, it's important to understand what compliance is, and we talked a little bit about that with each of those requirements. It's also important to know what it's not about, or what it's not based on. So compliance with the final rule is not based on a physical or geographical location. So just because my assisted living or my group home, for example, are in a residential setting or a residential community or neighborhood, does not actually mean that I'm integrated with my community. It is not just about the physical structure being there. It's really, again, how is that setting supporting me to have meaningful integration with my community? It's not just about going bowling or shopping, for example, but how am I being supported to start developing relationships outside of those people with whom I'm receiving those services with. It's also not based on a specific diagnosis or a medical condition. The HCBS requirements that we've been talking about are applicable for every HCBS program, people of all ages and all disabilities. This is not, well, people with this disability, it's not applicable to, or it's only applicable to people with this disability. It is not about that. And it's for everybody from 0 through the time that they are no longer on that waiver, whatever age that might be, or however that may happen. It is everyone. The setting doesn't support, or the final rule doesn't support blanket restrictions on individuals' support and their experiences that are not person-centered. We'll talk about this more as we go through the next section, but this is really about those settings that have those blanket visiting hours, for example, or those set meal times, or nobody gets to leave the setting without somebody going with them. That's no longer allowed. It really has to be done on an individual basis. And we'll talk through what that looks like and what that means as we get to the next section. So we've talked about the settings, what those requirements look like a little bit, but let's talk about the other piece, is that person-centered planning, what that means for people and what that looks like. So person-centered planning requirements, the final rule does require that a person-centered plan is developed for each person receiving services, and that it's developed through a person-centered process that's really driven by the person. It's really no longer a group of people or somebody dictating that. The person's at the center, they're driving that to the extent that they want and leading that process. So the final rule does establish those requirements for service planning, which means, again, it's directed to by the individual to the maximum extent possible. Really, the job of the person who's helping to develop that service plan is to talk with the individual about how much they want to drive that process or not drive that process. Maybe they want support, and that is okay, but they get to have that decision, and they get to know that they have that right to lead this process for themselves. That the planning team, so whoever's involved in developing that service plan, are the people chosen by the person. I've worked in a lot of states with a lot of settings and providers where there's just an automatic assumption that all these people get to be involved in that service plan process, that the providers who are providing services get to be there. It's probably a good idea that they are there, but if the person doesn't want them there, they don't get to be there. Doesn't mean they don't get contacted or involved in a later way, but at the time that meeting is occurring to develop that service plan, the people sitting around that table or sitting on the Zoom meeting should really be chosen by the person. The service plan meeting must also occur at least annually. So everyone is required to have an update no less than annually at those times and locations that are convenient for the person. So it's no longer this system of, I'm your case manager, I have to do your service plan. I'm coming over at noon on Monday to do it. There's now a conversation of what works best for your schedule, because maybe they're going to be at work on noon Monday. So what works for their schedule? What's the best location for them? Maybe it's not at their home because maybe they do want to do it on their lunch break, for example, or at their day program. So it's really what's convenient for the person. And that service plan is reviewed and revised if needed when those circumstances change or when the individual requests a review or a revision. So it's not likely that everyone's circumstances remain the same for an entire year. People get sick, things change. I think the last couple of years, lots have changed for everyone over the course of those years and within those years. So that there's the opportunity to review what that service plan says, what's going on with it, when my circumstances change, or if I say I'd like to review this and make some changes to my services. What has to be in that person-centered service plan? There are a lot of pieces that go in here now. The plan has to include the goals and desired outcomes that are identified by the person. So in my history of working with programs, I've seen a lot of goals developed that say the provider wants wants Brittany to participate in her physical therapy, or Brittany's mom wants her to become more independent with X, Y, and Z. Those may or may not be my goals as Brittany. So we're really looking at what are the person's goals and what do they want to have come. Those goals they can be related to my activities of daily living. Maybe I do need help and I want to make sure that I'm taking a shower every day. But if I want to save up for a vacation, that could also be my goal. Maybe I want to go to Hawaii next year. That's a very reasonable and personal goal. So I think the piece to remember here is that the goals are personal. They don't have to be related to only what services can provide. And we document then, once we've identified what my goals are, what are the supports I need to achieve that goal? It may or may not be something that the HCBS waiver provides, but we're also looking at other supports. What are those natural supports? Who are those state plan benefits potentially, or community resources? But it's personal to the person. The service plan must also reflect both those paid and unpaid services and supports. So who or what are the agencies providing those supports for me? If I do need help with maybe money management, for example, it doesn't have to be provided by the HCBS waiver. It can be provided by a relative, or maybe there's another community resource. Or do I have, again, a state plan need because my doctor is providing something for me based off what my assessed needs are. It's not just related to what's in the waiver. The service plan also has to document the risk factors and strategies in place to minimize them. So once we've identified what a person's needs are, we've also identified in some way through our assessment process what the potential risks that may exist for the person. And it could be that maybe I have an identified need, and where I live, there is nothing to help support or meet that need. So we're documenting that. And then how are we minimizing that? What strategies are we putting in place? Are we looking at, maybe there's just some more natural supports to help with something, for example, but we're documenting those factors, and then how are we going to mitigate or minimize those? The service plan also has to be understandable to the person and those who are supporting them. So what a lot of service plans in the past have been written in, the jargon that I think a lot of us use in our field. We don't want to use that anymore. We want to write it so that the person who it's about and for knows what's in it and can understand it and knows, easily understand what their needs are and how those needs are getting met and their goals and etc. The service plan also has to identify the case manager or the case management agency who's responsible for monitoring that service plan. So who is the entity and or the person who says, okay, we've developed the service plan. Now we're going to monitor and make sure that it's being implemented the way in which we've all agreed upon. Are you getting the services you're supposed to be getting? Are you getting them at the frequency you're supposed to be getting them, in the way that you want to be getting them? And if you're not, what's going on there? Let's talk about that and let's make those adjustments. So we're documenting who's doing that for the person. The service plan also has to be finalized and agreed to with informed consent of the individual who it's for in writing, and then signed by all who are helping to implement it. So whoever those HCBS waiver providers are, they're signing that. Potentially natural supports, they're signing that. Then all of those people get a copy of it, as well as those agencies involved in the plan. So it no longer just gets to sit with maybe the case manager, but the person gets a copy. Anyone else they want to have a copy, get one, as well as again those agencies helping to implement it. The service plan also documents those services that they've elected, that the person has elected to self-direct. So not all waivers allow this option, but if that's an option through the waiver and they want to self-direct whatever those services that are allowed through that program, we're documenting that they have chosen to direct maybe their personal care, for example. The service plan also really prevents the provision of unnecessary or inappropriate services and supports. When you start to develop a service plan based off of the person's goals, their assessed needs, and identify all the options available to getting those needs met, we really start to diminish the amount of unnecessary or inappropriate services that get authorized. So it's just, that helps with this new process. And then we're also documenting any modifications to my rights. And we'll talk about this in a couple slides. It goes along with that blanket restriction from a few slides ago, but we have to document those modifications. And there's a whole list of information that we have to document, and then that I'm consenting to those modifications. So we'll get there in just a moment. Along with the service plan development, and throughout the settings final rule, we've talked a lot about informed choice as well. Individuals do have the right to choose who is providing their supports, from the agencies providing them to, as much as possible, the individual, like the direct service providers, the one who are actually helping the person or supporting them. I've worked a lot with agencies over the years where, I'm a residential setting, but I also provide day supports and employment and all these other things. And there's been this history of just, well, since I'm providing this, we're going to be it for you. And people have not been given informed choice that there are so many other providers that can do that. So we're really looking at that for people with the final rule, is that informed choice of who's doing those services and providing them. That informed choice of where I'm living. What are all the options within the waiver and just within my community or wherever I might want to live that are disability and non-disability specific. I have informed choice of who I'm living with. Again, if I'm living in a residential setting, do I have the ability to tour that setting before moving in to see if I want to live with those people? If I have to have a roommate, do I have that choice? I get to make that choice, and it's informed. I get informed choice about what to do with my time, and if I want a paid job. I'm not just automatically assumed, or it's not just automatically assumed because I'm in this program or I have this disability that I have to go to a day program all day. If I want a job, regardless of my age, am I supported to do that? Am I informed of my choice and my ability to do that? And informed choice on what to do with my resources. How am I spending my money? That's my choice. I have the right to control that. So I'm informed of all of these pieces and know that these are my rights and that I have choices to make with all of these. So as much as we've talked about some rights, there are modifications that can be made to those rights. As I said, CMS, when they put this rule out, we are really starting to, again, look and work with people and as individuals, and not as their disability or their age or their diagnosis. However, CMS and the federal government also recognized that some people may not be able to exercise their rights in the same way as everyone else, and that providers can put some modifications in place to help ensure health and welfare of a person. That is also a job of a provider, is that health and welfare. So CMS didn't say, chuck that out the window, we don't care about it anymore. We do care, but we're doing it on an individualized basis now. No more of this, you're a person or you're a group of people with this diagnosis, so you don't get to do these things anymore. So if somebody needs to have a modification to one of their rights, maybe access to food, for example, or visitors at any time, or any of those kinds of pieces, it has to be based on a specific and individualized assessed need. So what is the need for that modification specific to me? Now, maybe I have a diagnosis of dementia, but I think if you worked with people with dementia, that does not look the same with everybody. There are different stages of where people are at. How it presents in people is different. And so it's no longer okay to just say, you've got dementia, so you no longer get to have food at any time. We have to monitor that for you. Not okay. Maybe I have dementia, but because of X, Y, and Z, which is my assessed need, I have to have a modification in place. And so what are you modifying? You're modifying my access to food, for example. Before you can also implement that modification, we have to document what are those positive interventions and supports that have been used prior to any modification. How have we tried to do this differently before saying you can't have access to food on your own or access to food at any time? And what have been those least intrusive methods of meeting my need that have been tried but did not work? So what have we done before? What are the positive ways we've tried to do this? What are the starting from step 0 before going to step 6 that we've tried to support this person and address that need before we implement a modification? And if those steps have been tried before, Maybe I'm moving into a new residential setting, a new assisted living, for example. And I either lived at home and or lived in other, assisted livings that have tried steps 0 through 5 and they weren't working. The new setting can absolutely say we want to start at step 6, but they have to document all these other pieces first. We also have to describe, a clear description of the condition that's directly proportionate to the need. So again, is there a diagnosis? And maybe there is, and there can be. That just can no longer be a sole reason for saying somebody can't do something. We're also documenting the regular collection and review of data to measure that ongoing effectiveness of the modification. So you don't just get to put a modification in place and not determine if it's even working, or reviewing information to see, is this doing what we intended or what we were hoping it would do? Along with that, what are those timelines for reviewing that to see if it's even still necessary, or can it be terminated? Some modifications might be needed ongoing. It still doesn't mean they shouldn't be reviewed for effectiveness and reviewed regularly to make sure things are going okay. Some modifications might be terminated. Maybe I struggle in new environments. So if I move into a new assisted living, my history has shown, I've exhibited certain behaviors, but after I'm adjusted, after, 2 or 3 months, I don't exhibit those behaviors anymore. So maybe that modification can be terminated. So we're reviewing this regularly. Again, informed consent of the person. A provider cannot just say, I'm modifying your right. The person has to agree to it. And on the flip side, or conversely, a provider can also say, if this individual doesn't agree or consent to this modification, I don't think we can safely provide services. They can do that, and then a conversation is had with the individual and most likely their case manager about options for other providers, but the individual does have to agree to have their right modified. And last, before modifying somebody's rights, is you're documenting an assurance that whatever you're implementing will not harm the individual. So maybe staff will need training on whatever that modification is. So you're documenting that you're doing those things to make sure staff are trained, upon implementation, annually thereafter, or whatever it might be. But we have to document that we're not, or that we're assuring that we're not harming that person by doing this. So what comes next? When we first started, we talked about the final deadline for compliance as of now is that March 17th, 2023. So what's happening? What is going on? Some recent updates from CMS. In May of this year, they announced a new strategy to help states comply with the final rule. CMS has been working with states since 2014 to help them come into compliance, and that's done in a variety of ways. All states have had to submit a statewide transition plan that documents, what are the waivers or programs and settings impacted by this rule? What is the, their systemic assessment? So what are the regulations and statutes and processes and all those pieces in place that maybe don't comply with the final rule? Where are providers currently at in compliance? They've had to assess providers and get information from providers about how they will come into compliance by March of 2023 if they haven't already. Throughout that work that CMS has done with states, and then with the public health emergency, they've reevaluated some pieces and updated and created a new strategy that we'll talk about, which really started to stem from the direct service workforce crisis in general. If you pay attention to any of these kinds of programs and aging and disability type services, there has been a workforce crisis for years prior to the public health emergency, but the public health emergency made it worse. There are less people providing this work. I think if you've looked at any of your, any state ARPA spending plan, so many of them have said, we want to do something about rates for workforce retention and, recruitment. So CMS took that into account and said, however, even though we're going to give you a new strategy, the priority is really to make sure that the final rule is implemented in a way that's really meaningful for people, while recognizing and reflecting the realities of that current workforce crisis and the public health emergency. So what does that mean? States still have to receive final approval of their statewide transition plan. That has not changed. That has been the case since day one, although dates have changed. They still have to do that. But they have changed some pieces of what providers must be in compliance with by March of 2023 and what there's a little more time to work on. So the areas that have to be in compliance that were not impacted by the public health emergency: privacy, dignity, respect, freedom from coercion or restraint, control of my personal resources, having the lease, having privacy in a unit, lockable doors, decorating as I wish, access to food, access to visitors, physical accessibility, and that person-centered plan that's documenting any modification to rights. Those still have to be done by March of 2023. Providers have to have all of these pieces in place by that date. The reason is those aren't rights or those aren't requirements that are really impacted by PHE. Those don't require additional staff or staff to individual ratios that must be met. Those are things that just need to exist and can't exist without that. For those other areas, CMS is allowing states to submit a corrective action plan that will provide additional time to achieve full compliance with those areas that have been impacted, such as that integration and access to community, which includes competitive integrated employment, choice in staff, choice of non-disability specific settings, option for a private unit, for example, and or choice of roommate. Those pieces do require a different level of staff and workforce in general for whichever ways in which those are implemented. So states do have a little bit of time. They can submit a corrective action plan, but that action plan is time limited as well. It is not a forever thing, and it's states really need to be thoughtful about their approach there to identify which settings that's applicable to, potentially maybe which services, for example. But again, it is not forever. It is time limited. But that is something that came out this year. States are, I think, looking at that. We had a HCBS conference last week in DC. CMS was there. There are still about half of the states who have not received that final approval with their statewide transition plan either. But they did talk about this being an option for some of those states. So we'll see what states do with that. We'll move on to, I think, questions and any questions or any discussion that you all might have.
So I'll come back on for that part. And we have one question from attorney who actually specializes in a lot of areas you're dealing with, Melissa. And then after that, if other questions pop up, we can take the other questions. And if there are no other questions that pop up, I certainly have questions. So I'm just going to read this. It's and it really is. I think the question is just looking for a response, really, like a reply. In California, some of our services already have to be compliant with the final rule, and that's the Regional Center's Self-Determination Program. Maybe you've heard of that. Okay. We are being prevented from funding some social skills classes for kids. I guess these are younger people, since they are considered to be integrated or in a community setting. Maybe it's, and then it says, generally the social skills classes are about 1.5 hours per week, and generally for kids with all special needs, since they are the ones that have social skills needs. And I'm guessing, and Melissa, you can respond and correct me if I'm wrong, the issue is that, no, not, yeah, that's what I meant, not. They're the kids, or these could be adults too, whoever they are, they may be in some community setting, but for social skills classes, they would want, the option would be to go into a class which just has people with disabilities in it. And Melissa, you can correct me if I'm wrong about that. And that may not be compliant. Response, Brittani, unless you want me to elaborate. Do you understand what she's saying? Probably, but
I think so.
Yeah.
Is it everyone okay if I exit the show and I just pull up the the question as well?
Sure, sure, of course.
Perfect. Sometimes I'm a visual person. Let me stop that there. Was that in the Q&A, Terry?
Yeah, that's in the Q&A. So it's really, I guess that's the general concept. You want this integration, you're saying, but, oh, we have certain settings that you're just going to be around people with special needs only. For this one's an hour and a half per week, but it could be, for any period of time. Can that happen and still, does it still comply with what this final rule is all about?
There's nothing that says you can't have something that is maybe, disability specific, but I have to, as a person who might be receiving services, they are offered the choice of all the options. States can also make decisions too, in terms of when they think of, when they say somebody should be compliant and maybe how funding goes, but nothing says you can't have something that is specific for a group of people. That is just not the only option that should be given to somebody because you have this disability. So this is all you get. They can have the choice to do that, but the choice has to be documented and that they were given all these other options as well.
Got it. Very, very helpful. It's the choice part of it. Okay. Another question we have is, can you provide some strategies, tips for meeting the choice of staff requirements in residential facilities?
Sure. It's tricky, right? My preference might be for a female caregiver. If I need help with some personal care, I might want a female caregiver. What we're looking at here is really that if you are a setting, let me back up. As part of my service plan, when we're saying, what are my needs? The other piece that gets documented are my preferences for receiving those services. So if I need help with bathing and dressing, for example, my case manager might say, do you have preferences about that for yourself? I might say, I would prefer a female caregiver. So as that case manager is helping to find services for me, that gets shared with those potential service providers. And it might be a provider that says, well, at this point, we only have male caregivers, so we can't meet that. Or in general, we could probably meet that, but if somebody calls in sick or, things happen. So it's really just about being upfront at the beginning. If you don't offer that, then acknowledge that to the person. If you can, acknowledging that as well, but also acknowledging that there might be times that it can't be met. Again, if people call in sick, if there are emergencies, things happen, and that's okay. So it's just about recognizing what this person's preferences are and recognizing if you are able to in some way accommodate that at all, if never, and having a conversation if there are times that it can't happen. And other pieces too, if maybe I prefer a certain caregiver, right? There's somebody I've bonded with who I get along well, or maybe I'm not getting along with somebody, that there's also the ability for me to voice that that concern and that make that request to say, you know what, I don't enjoy working, having James help me with whatever the tasks are. Can I work with somebody else, or can I work? And seeing if that's possible, making accommodations when possible.
Got it. And I happen to know quite a few of these attorneys who are asking questions. They're very, we've got a very experienced and, top-notch group here. Okay, Judy, question. Does the choice of a conservator count as the choice required for the final rule, even if the person can speak for herself?
Good question. And that's tricky. I definitely will not, I will not give any legal advice because that's all you guys. That's definitely not me. But I think what's important here is what is, what's in that conservatorship? What are their responsibilities in that? And even with that, or even with guardianship, it shouldn't completely negate the person's choices. I think, from any perspective, any provider or case manager would want to have a copy of whatever those in those documents so that they know who's responsible for signing, who is ultimately the decision maker in those pieces. But it doesn't mean we don't have conversations with the person and hear what they're saying and want to take into account what their goals are, what their likes are. depending on what is going on, that might be an occasion where there are some modifications because of maybe the need to have a conservatorship, but it's hearing from all those pieces, and I think really understanding what's within that conservatorship, what does that person have the right or authority to do or not do for that person.
Okay, and I'm gonna, until we get more questions, I'm gonna ask some for the last 5 minutes, but I'll interrupt whatever I'm doing if another one comes up now. It's a wonderful, it's wonderful. You hear it and it's you know, a great thing to be doing these things. However, here's my however, to really do this right without just being kind of a compliance oriented operation, you need certain people who really are the people who make things like this happen. And there are people out there, and it's kind of comparable, I'm thinking, to in young kids, like the inclusion coordinator for people with disabilities in regular classrooms. But there you have a classroom. It's like easier. You almost need you need an inclusion coordinator plus involved. Is there any funding mandate for paying for these people through sources from federal or state government?
No. The short of it is no.
Okay.
The federal government, when they implemented this rule or made it effective, did not provide states with any funding to do anything, to give to anything. ARPA funding, if states had put some of that in their plan, could have been used to support some of those kinds of pieces, but there wasn't any funding.
Okay, and so to follow in someone, I mean, Melissa earlier mentioned, you know, self-determination. So I guess if someone has self-determination and they have a component in there that really wants to make this happen, that's probably a good thing. Everyone's going to like that, I suppose, because whatever component in the self-determination plan is in there is something that's really making this happen, what the goals are. But there's no extra funding for it. People have to find their own creative ways, and self-determination does it. By the way, speaking of self-determination, are people, is that something, that's what we call it here in California, but are you seeing that in other states? Are you familiar with it? Because it was the original question for Melissa, that it sounds so much like what quote unquote self-determination is for people with developmental disabilities here in California. Any comment on that?
I think it's different. I mean, self-determination, I think, is used a little bit differently. I don't know a lot of states that have a self-determination program that way, but there are states that do self-direction, which might be a little similar to self-determination. I'd have to look into that a little bit more for that specific program, but I think it depends on how the states are defining it and what terminology they're using. But
okay. Let's see. Another fine attorney here, Carol. I know these folks. One of them is about third-party trust. I think that's more trust administration. But then Carol asks, what is the boundary between the final rule and the UI/undue influence facts? I don't know if I understand that question. If you understand it, fine. Or Carol, you can put something else in to elaborate it. Unless Brittani, does that?
I do not know it.
Yeah, I don't understand what that is too. Carol, in the meantime, you can throw something in there while I'll take another minute and pop if you want to clarify that question. And in the meantime, I want to ask, does this apply? We were talking about some normally institutionalized settings, assisted living, group home, but because, I mean, for example, in California, the in-home supportive services program is out there. You can't really see what's a waiver and what's not in the program behind the scenes. I mean, there are a lot of parts of the program that are waivers. And in regional center services, I'm sure a lot of parts of the program, they don't come at the consumer in a way that you can identify, oh, I'm getting funding that's going to require these things, but it probably is. Does this apply to everyone? I mean, all people in California who are getting in-home supportive services and they live someplace, it applies to them? Question mark.
It fits through the HCBS waiver. Yes. So I know that in California, some of the waivers, I know there's the DD waiver for the
Right.
there's the assisted living waiver, there's the home and community-based alternatives waiver.
Right.
It applies to all of those. So those services within that waiver, the states also, as they were creating their statewide transition plan, looked at which actual services does this apply to. It doesn't apply to every service. There are a bunch in the DD system that it didn't apply to. But I believe the in-home support services, if at least fits through the waiver, it does apply.
Some of it does. I mean, some of it goes to a waiver, but it's hard. I don't know, behind different components come from different things. And that means the same thing for people with developmental disabilities. You can count people who are getting services from our regional centers here. Let's say, for example, more traditional services, supported living services, independent living services. Somehow a waiver is touching those services, ? And therefore, and I just don't know about it because they don't call it that when it doesn't come in the door as a waiver. But all of those folks getting SLS, ILS, probably most of the things from self-determination, I'm guessing, there's some waiver touching those services, separate even from HSS. And this is a long sentence with a ? Which means those people are going to be subject to the final rule? ?
Yes, most likely, yes. California does have their initial approved statewide transition plan on their website. If you just Google California DHCS STP, you'll find it. That does lay out which programs and which services were included in their assessment and in this piece. It's a great resource just to become familiar with that, but that would give you all the details specifically for the various programs and settings/services.
And I'm going to try to get one more question in here from Melissa. The DDS, Department of Developmental Services website, says that services provided in the family home are presumed to meet the requirements of, I guess, the final rule. And is that your understanding? And then I would like to just amplify that a little bit. What is the family home? Is the family home a home where a child is living with his or her parents? Or is the family home when a child is, or adult child, it was someone who's living outside that setting, which I believe is a requirement for, let's say, SLS and ILS?
So
you think,
yes, if they're living in the family home, that's from CMS. So if I'm a child receiving services living in my parents' home, we're presuming that's compliant. If I am an adult living in my parents' home, or maybe even my own apartment or whatever, presumed compliant.
I want to just focus on that. That is because that's the parents' home. We got your own home, which is almost any other home. Are you saying you were presumed compliant if you were living in your own home? That's someplace outside of a group home, et cetera. It's just a living waiver. So there's a presumption of compliance if you're in any of those settings. And what does that mean, a presumption of compliance?
It means that, especially in regard to a child, there's not a lease for a child who's living in their own home.
Usually as an adult. An adult's probably more. That's what that'll come up because there are many adults, right, who are out there. So all those adults out there who are receiving regional center services, many other services, and they're living in a home other than not a licensed place, a facility, there's a presumption of compliance.
That I have access to food, that I can have visitors when I want, etc. So,
but how about community integration? How about that?
There's that presumption that they're just compliant. It's when you start to look at those services outside of the home. So again, those day programs, for example, and then those residential settings that are owned and controlled by the provider. That is what is presumed. I don't want to say presumed not compliant, but that required the assessment of compliance. States did not have to go into a family's home and do an assessment and ask to see all their documentation on policies and all these things.
Mm-hmm. So that's, and could you add one more, anything else on what presumption doesn't mean it's conclusive, right? It means
No, they're
rebuttable.
just presumed compliant, that we're just assuming that they are meeting all of these requirements because it's the family home. It's not controlled or operated and owned by a provider where they then have all these other policies that get put into place. Your family home, I don't have policies in my home,
Right.
with all these things. So there's just
But
an
it's
assumption
controlled
that-
but that's going to get into nuance. Controlled by provider is that's operative.
owned and controlled. Yeah.
Yeah, owned and controlled. And I think, has a will over someone to gain advantage, expense of a trial necessary, how to comply. But this is more, Carol, I think that's a more, I think there's a last question, but I think it's a pretty elaborate one. And I think we went over already. So, but I think that's, I'll ask a real quick. I don't think there's something here but when a patient with a mental illness has a will overborne by someone seeking to take advantage, the expense of a trial necessary to determine how to comply with the final rule. That seems very legal to me, right, Brittany? That's not your.
Yeah, I definitely don't.
Okay, well,
I won't speak to that.
Okay, with that, I will just say thank you so much for a great presentation. Boy, was this, it's something learning about all these things. And it's really appreciated that you came on to help us with these matters. So thank you, Brittany. Thank you, everyone in the webcast audience. We'll see everybody next program.
Thank you, everyone. Have a great afternoon.
Bye.